I'm George Curtis. Welcome to It's Your Law. Each week it's my privilege to bring you guests that help all of us understand the legal process a little better, criticize it, see where it can be improved, and make decisions as to how we as individual citizens are going to improve it. Each week I have interesting guests that have some input that we hope is interesting, useful, and educational to you. My guest today is attorney Mike Kuborn. Welcome to the show, Mike.
Thank you.
You work here at our new offices, 3475 Omro Road, which is just about a mile toward Omro, or a mile west of 41. How do you like our new offices?
Well, I like them a lot, actually. I think we've got an easier location for many people to get into, and certainly an easy one to find.
And lots of parking. I think about 20,000 cars a day go to and from Omro, Red Granite, and into Oshkosh and back out of Oshkosh. We seem to have a lot of exposure. People don't seem to be having any difficulty finding our place.
That would be true.
We're going to talk to people today about the legal system and some things that are developing and have recently developed that could impact their lives. When people think of Curtis Law Office, I think they, in most cases, think of auto accidents, because I've been representing injured people against insurance companies for 52 or 53 years. You called to my attention that in the last less than 20 years I have filed over 1,400 personal injury cases. That's when the records have been kept by CCAP. I suspect the total would be over 4,000. You have filed a great number of them yourselves, and we do a lot of that kind of work, but that's not all we do. And I think people should find out that Mike Kuborn has a couple of other specialties that may offer services that they may need in the near future. One of them is divorce, family, custody, family law, I guess you'd call it. Why don't you describe what's encompassed in that?
That would be correct. Family law actually encompasses quite a few different items. Besides what most people would have come to mind, a divorce situation or the termination of a marriage, there is probably these days almost an equal number of what we call paternity cases. Cases where the parties have not married but have at least one child together, and they have many of the same issues to decide as those who seek to terminate their marriage. Custody, placement, some financial arrangements, and in certain circumstances even property disagreements.
So with many people living together today, as we used to say, without benefit of clergy, some of them have children, some of them bring children into the relationship, out of the relationship, and back and forth. There are some legal rights involved, not only the two adult participants, but children.
That would be true. Here in our system, we utilize something called a guardian ad litem, an attorney appointed to represent the children when the children's interests are part of the dispute. And in addition to what we've already mentioned within family law, there are also situations where we change between different relationships or different marriages, and we look at possibly adopting children or changing the children's legal direction at least.
So if the parents are not married at the time of conception or birth, it's almost even more complex than if they were married.
In many cases, that would be true.
And what are some of the protections of being married in terms of the protections of the child and protection of the adult litigants?
Well, unlike a paternity case, when a person is married, under our current laws at least, both parents have access to the child. In fact, there's a presumption, rather strong one, that there's going to be joint custody. Custody being the ability of both parents to participate in significant decisions for the children. Their religion, where they're going to go to school, when they get older, things like entering the military, when they can get married, things of that sort. Those custody decisions are something that are granted to both parents in a marriage, not necessarily in a paternity case.
Our population is kind of fluid these days, at least compared to when I got out of high school in 1954. And so people may move multiple times due to employment or other situations in their lives. What happens when somebody wants to move, there's a child, and the other party to the marriage or relationship doesn't want to move, where does the child go?
That's usually a difficult question and creates many of the disputes that I work with clients on. Here in Wisconsin, if you're going to move at least 150 miles away, there's a specific statute that triggers notice provisions and the right to a hearing. But even moves that are less than 150 miles can certainly cause significant problems with existing placement schedules, where children are going to go to school, things of that sort. So there are many disputes that don't trigger that notification process, but still obviously will require changes.
We haven't mentioned grandparents. They've got some rights too.
That would be true, and it's something that more and more people are exercising, particularly in the kind of mix of nuclear versus non-nuclear situations that we have these days. Many grandparents find it necessary to commit to some regular visitation, particularly with children that they've had some stake in raising. In other words, parents who are at lower end scale jobs, as an example, tend to rely on their parents for things like daycare, and they can become a central person in each of those children's lives. And of course, to preserve that relationship, sometimes a grandparent visitation schedule will be necessary.
In today's fluid society, it sounds pretty complex. My instinct is to tell people, don't do this alone at home by yourself. As soon as you have a question, call a professional, call an attorney. Is that good advice?
Most definitely. Whether you need to retain one or not is going to be a product of your particular situation, but you should always at least seek guidance so you know what your options are.
And the longer you handle it by yourself, in the long run, the more expensive it's going to be, because it's hard to uncrack the cement.
Even more so in family law than some other areas. We have a provision, as an example, that after an initial judgment in a family law case, the court presumes that those arrangements have to continue for a 2-year period, barring some rather significant needs for change.
So call first, act later.
Most definitely.
Let's take our first break, and we'll come back and talk about employment law. That's certainly in the news. Welcome back to It's Your Law. I'm George Curtis, and my guest today is attorney Mike Kuborn, a former Marine, a former member of our state patrol, a member of the bar in Arizona and Wisconsin. He does a lot of automobile litigation, as this firm has been known for many years, but that's not all he does. He does employment law and family law, and things that are very much in demand at this particular time. I'm personally interested in employment law because there have been some recent changes, haven't there?
Quite a few, as a matter of fact. In a nutshell, a lot of protections that our employees here in Wisconsin used to have are no longer available. For the most part, the two basic categories of employees, either those that are covered by a contract, which would be primarily professional entities, CPAs, doctors, things of that sort, are now in the minority. The vast majority of us are what are called at-will employees, and very few of the rights that at-will employees used to have in Wisconsin still exist.
For example?
As probably the primary example, they used to have the ability to require their employer to follow certain steps before termination. If those steps weren't followed, there could be a breach of a non-contractual agreement, which could have given them some rights in litigation in particular. But most importantly now, the at-will employee also has no protections in terms of many of the hours of work provisions, or in other words, what it is that their employer can require them to do in order to stay employed.
Well, anyone who reads the newspaper or listens to the radio or watches television is aware of the controversy we've had in Wisconsin with regard to public employees being stripped of some of their rights, their ability to negotiate and effectively bargain for protection. That's been in the papers all the time, and it's affected the number of people who are even willing to go to school to prepare for public employment. But you're telling me, or at least giving me a hint, that the rights of private employees non-public employees have also been weakened recently.
Very much so. In fact, it's to the point now where an at-will employee outside the public sector, because there are still some protections within the public sector, more so for police and firemen, but even those public sector employees that are not law enforcement or fire protection related still have a lot more protections than your typical at-will employee. Plain and simple, at-will means you serve at the will of your employer. They can let you go at the present time for any reason or for no reason.
Well, I have clients, personal injury clients, who come in with a dour look on their faces, and a typical story is, I've been working for a marine manufacturer in Fond du Lac, or one of the employers around here, for 20 years, and they decided they didn't need my job anymore, and so I have been laid off because my job doesn't exist. But now I see a younger man doing basically the same thing at half my hourly rate, but he's got a different name and a different classification. This doesn't seem to be right. It doesn't seem to be American. And I say, you have to talk to Mr. Kuborn. What do you tell him?
Under certain circumstances, moves like you just described can certainly violate other existing state and federal laws. What we're talking about for the most part is what we call discrimination. There are 13 protected classes under state law, and 7 of those are the same under federal law. An employer cannot treat a member of a protected class differently just based on their membership in that class. So in your example, we'd be talking about age discrimination, utilizing a series of moves to eliminate aged employees, primarily because they come with longevity and greater pay requirements, in order to produce a younger workforce that costs them less.
We have a well-respected work ethic here in the Midwest. I think that that's recognized throughout the country. Our people believe in earning their pay and working hard, and they're good employees, and as an employer of nearly 50 years, I can vouch for that. Now, with fewer protections, what advice can you give potential employees to protect themselves so they don't get caught in midlife without a job and without the opportunity of getting a job that paid anywhere near the one they lost?
Well, I would recommend 2 things. First of all, being as familiar as you can with the benefits that you do have available. So, for instance, what happens with many of our personal injury clients that are severely injured, if you need to take time away from your employer, it's due to a sickness or an injury, you do have some protections, at least for the first 12 weeks. Known as the Family Medical Leave Act, that's probably one of the biggest protections, but there's a lot of other protections as well. You need to be familiar with those. And I think in today's situation, and particularly in an economy that hasn't quite bounced back yet, you need to be in a position where you can save a portion of your income, because you don't know what tomorrow's going to bring.
So I think what you're telling us is you better anticipate that there are rainy days ahead, and if you can have a little bit of a backlog of resources, you'll be able to meet them a little better. But I suspect this is something else that we have to talk to experts about. What happens when, for example, your company decides that they're going to close one of the plants in Winnebago County, but mysteriously they're opening one in Little Rock? How can you protect yourself for that?
There are a series of laws that, for mass closures, require the employer to provide certain notice, and if that notice is not provided, may in fact provide some additional benefits for the employees. That would be another area. As soon as you have notice, even if it's unofficial notice that something like that may be occurring in your workplace, you need some legal representation.
Well, we're kind of a consumer law firm. On the auto accident area, we represent individuals. We don't represent insurance companies. When it comes to labor, do you represent the corporations or do you represent the labor?
I represent labor, both employees, and I have had the opportunity periodically to be involved with several of our local unions as well.
All right. And your advice to folks, if they have a concern about their employment because of something that's happening within the job, or they're just worried because they've got a family to support, what do you suggest they do before it hits the fan?
Most importantly, know what your options are. So for the most part, in an employment situation, that's going to involve a call to a lawyer that specializes in the employment area.
Again, be forewarned and forearmed and be educated, and don't be afraid to call a professional. What does it cost them to make a call to Mike Kuborn?
Absolutely nothing.
Let's take our second break and we'll be back and talk about something else. Welcome back to It's Your Law. I'm George Curtis. My guest, Mike Kuborn, who is an attorney here at Curtis Law Office, and I are at our new offices on Omro Road, 3475 Omro Road, about a mile to the west of Highway 41 on your way to Omro. You'll see our sign on the north side. We've got nice offices, nice parking, and we'll be happy to see you. Our firm over the years has been best known as a personal injury law firm. That includes auto accidents, plane crashes, bad products, construction accidents, and things that go wrong in the workplace where people are injured. Those laws have been changing as well, and they haven't been changing in favor of the injured person. This is a political issue, and of course we were in an election year, and I want you to pay close attention. We're not going to tell you who to vote for. We don't do that for anybody, and we can't even tell each other how to vote. But at the same time, we must understand that the folks in the Congress, in the legislature, in the governor's chair do impact your rights. And Mr. Kuborn, what direction the protection of injured people been going in the last 5-8 years?
On two fronts, it's been much more limited. Number one, limiting the extent to which the insurance policies that each of us have and pay regularly for can protect us, and then changing a lot of the laws in terms of the process of actually gaining that protection or bringing your injury case to litigation.
Well, the politicians that obtain a lot of contributions, largely from insurance companies and the medical field and corporations generally, call it tort reform. Reform is an interesting term. To me, reform means taking the rights from one party and giving them to another. That's reform. You can't say it isn't reform. But the rights have been taken away from the consumer and the victim in most instances and have been given to the insurance companies and the potential defendants. My own personal insurance policies are worth about half what they were 12 years ago because of these so-called reforms. And yet my premium has gone up. How do you explain that?
I'm not sure that there is a logical explanation to that one. The same is true with my own. The protection that I pay regularly for, particularly in terms of concepts we refer to as UM or UIM, uninsured motorist or underinsured motorist, is now quite a bit less than what it used to be.
For some more examples that impact most families have more than one automobile, so they have to have an insurance policy required by law on each of their, let's say, 3 automobiles. They have to have med pay. Let's say they buy $30,000 worth of med pay, $10,000 on car A, 10 on car B, 10 on car C. So they're paying for $30,000 worth of health insurance. Under the old law, before the reform, if they were in an accident, they had $30,000 worth of medical care insurance, regardless of fault. But under the reform, where you can't have any stacking and where you have reducing clauses, they paid for 30, they can only use 10. The other 20 is a gift to their insurance company. Collected the money, sold the product, but doesn't have to deliver on the product. That's one of the forms, isn't it? That's a reform.
Most definitely. In fact, here in Wisconsin, the insurance companies are now allowed to go one step further. For that $10,000 worth of protection that you're left with, they can now put on a different hat and pretend they're a health insurer and tell you that they're not going to pay portions of that $10,000 to certain treatments because they don't feel they're related to your accident or illness.
There's another term in the reform called stacking. It used to be dealt with as a reducing clause. You buy $500,000 worth of or underinsured motorist coverage because you need it. In this economy, 25 to 30% of the people out there either have no insurance or too little insurance. So you buy $500,000 to protect your family and the people that are in your car. However, under the reform, if the other vehicle or vehicles involved in this accident have, let's say, $150,000 or $200,000 worth of coverage, you bought and paid for $500,000, but you don't get $500,000 from your insurance company. It's reduced by the amount of insurance that the other people may have. Another gift to your insurance company from the government. I wonder who your insurance company is going to be contributing to in the next election.
Certainly more of those reformers, I would think.
And some of the other reforms, they have so weakened the law of protection for our elderly in nursing homes, so that those folks who see the accident that happens to grandma can't even testify. Their testimony is not admissible. They're prohibited from testifying. The I'm sorry legislation, that even if a doctor admits that he cut off the wrong leg, that's not admissible in evidence. New immunities. So many different people that have a lobby are immune from liability. Good Samaritan recreational immunity, school immunity, the list goes on and on. And so if you're injured due to somebody else's fault, the list of people that are totally immune because they had expensive lobbies and contributed to the politicians is growing and growing. The solution, besides a political solution of educating the public and getting people who really represent the people, the solution has to be self-insured, buying more insurance to protect your own family, because the folks with lobbies are getting away scot-free.
I would completely agree. Unfortunately, not every means of protection, or in other words, not every catastrophe that can befall you, is insurable.
Absolutely. I mean, take our medical malpractice law in the state of Wisconsin. There's over $1 billion in that fund because nobody's paying off for the negligence of doctors. That money is just sitting there unused. There are really more moose sightings than there are successful med-mal cases because the law is so kiltered in favor of the medical community. I think that people have to arm themselves with education and realize that things don't just iron themselves out unless somebody's ironing. And they had better get a hold of professionals who are just looking out for their side to try to influence these laws. Right now, the laws do not favor the citizens in any of the areas we've talked about today. We've got to be out there fighting for people, and I know you and I are.
Correct. But we can't do it alone. Certainly, everyone that casts a vote has the ability to affect that situation.
So get educated, get armed, vote, and talk to people who are on your side.
Correct.
Mike Kuborn, thanks for being on the show.
Thank you.
And thank you, ladies and gentlemen. These aren't easy times. The economy has been weak for a dozen years. It's difficult being a working person. It's difficult being a parent. It's difficult raising children even if you have two parents, and many children don't have two parents. It's difficult if a health calamity, an accident takes place. It's difficult to find that the law does not favor the victim under the current regime. What can you do about it? Educate yourself. Call an attorney that does the kind of work that you are interested in or may be confronting. And here's something I really want you to take to heart. Visit your insurance agent. Have that person evaluate your coverage, because when you are in that accident, when you do have the health calamity, the party that caused your accident and your injury is either going to be underinsured or not insured at all. You have to protect your family, and the only sure way to do it is by purchasing sufficient, good, full coverage for yourself. Protect your family. Have a visit with that insurance agent. That's my opinion, and I'm George Curtis.